The Honourable Dr Jocelynne A. Scutt is a barrister and human rights lawyer admitted to practice in all Australian states and territories and called to the Bar of England and Wales in 2014. She is one of Australia's leading human rights barristers, was instrumental in reform of the laws on rape and domestic violence, and has served as Anti-Discrimination Commissioner of Tasmania and as a judge on the High Court of Fiji. She is a member of the UN Committee Against Trafficking, a board member of the International Alliance of Women, and its representative to the Coalition for the International Criminal Court. Jocelynne was appointed an Officer of the Order of Australia in 1996 for service to feminist jurisprudence and issues affecting women, including the establishment of a publishing company encouraging female contributions. She was inducted into the Victorian Honour Roll of Women in 2001. An academic, writer and filmmaker, her latest book is Wage Rage for Equal Pay, Australia's Long, Long Struggle, which was published this year. And Beauty, Women's Bodies and the Law, Performances in Plastic was published in 2020. And there were many, many, many books published prior to that. An edited collection, Women, Power and Autonomy, Rights, Respect and Representation in Law and Society, is due out next, and she is working with filmmaker Karen Bushinsky-Lee on a film about Mary Shelley, Frankenstein and The Last Man. Tonight she will be speaking on visibility, invisibility and reclamation, Adela Pankhurst, Jenny Baines and Alice Souter in the Australian High Court. And now I would like to give the floor to the fabulous Jocelynne Scutt. Jocelynne, please.
Thank you. It seems like somewhat of an anticlimax after hearing all that horror. I mean, you know, all sympathy, and it is worse in Australia than anywhere else. That's true. Well, I'd like to commence my anticlimactic presentation by beginning with serendipity. And the wonderful thing about doing research is what you come across by chance. And I was doing a case and just happened to pick up a volume of the Commonwealth Law Reports. And flipping through it, I came across the name Pankhurst. Well, if one comes across the name Pankhurst anywhere, we all know who it must be associated with. And when it's in the Commonwealth Law Reports, it has to be Adele. And so reading this volume, when I should have been doing something else, there were actually two cases. It's 1919, when Adele Pankhurst was arrested and prosecuted and eventually appealed to the High Court of Australia. And it's really interesting to go back into history to look at what actually happened in those two cases, because it's about the invisibility of women. And unfortunately, sometimes we women contribute to that invisibility. It's a bit like some of the chat saying that if there are women who effectively collude in covering up what's happening to women, then we're in a real problem. And the difficulty with this area of history is that women do it without realising what they're doing. So I'd just actually like to go to this presentation, which is, yeah, it is coming on, that's good, and talk about this issue of invisibility. Visibility and invisibility and the reclamation. What happened in these two cases is that the women were demonstrating in Melbourne over the issue of wheat being exported overseas during the war. And because the bread was being exported overseas to the soldiers, to feed the soldiers, not ours, to feed the soldiers from the United Kingdom, it meant that the cost of bread was rising in Australia and ordinary people could not buy it. And thus the women were demonstrating in the park next door to Parliament House. And there are two cases that came up. One of them was Pankhurst and Porter. And this case raises the issue of whether judges are neutral or whether there's prejudice that operates within the criminal justice system. And the second one, Pankhurst and Kiernan, raises the issue of being hidden from history as well as being hidden from herstory, and why that happens. If we're hidden from history, it happens because we are simply obliterated. And if we're hidden from herstory, it's because women are not aware of the realities that go on in terms of how the system operates. And what, of course, we need to do is to take a stand on this. Anyway, I'll come to the point of what happened in Pankhurst and Porter. It was shortly after 3 o'clock, and the three accused, it was Adele Pankhurst, Jenny Baines, and Alice Suter, who were the ones who were arrested. And they were demonstrating in Treasury Gardens to about 5,000 and 6,000 people who were there at the time. Adela Pankhurst got up on a seat and addressed the people who were there. This is a direct quotation from the case, and told them to follow her to Parliament House, defying the police, and to break into Parliament House if it was necessary, and to see what Billy Hughes, who was the Prime Minister at the time, was going to do to get cheaper food for the starving people. Now, after she stood up on the seat, Mary Pankhurst also got up on the seat, but she was pushed off it. Pankhurst was pushed off it, and then Alice Suter got up on the seat, and she started to address the people. Alice Suter was 18 years at the time, and then she was pushed off, and Jenny Baines got up, and she was pushed off, and that was when they started to march towards Parliament House to demand that Billy Hughes, who was the Prime Minister at the time, do something about this, about the bread, and about the fact that the prices were going up. And the prosecution was taken under the defence power, the Commonwealth defence power. Because of the war, and because there was war at that time, it meant that the government, the federal government, had extra powers in order to police public order, in order to ensure that goods and soldiers could run about on the railway lines, because the railway lines were state run. But at that time, under the Constitution, the federal government could take over. And what this legislation said was, it shall not be lawful for any number of persons exceeding 20 to meet in the open air in any part of the proclaimed place for an unlawful purpose, or for the purpose or on the pretext of making known their grievances, or of discussing public affairs, or considering or presenting or preparing any petition, etc. And what the case ran on was this phrase, on the pretext of making known their grievances. And they were arrested because it was alleged that they were there demonstrating, and they were pretending to be there to talk about the bread and the cost of bread. Rather, they were there for some ulterior motive. We don't know what the ulterior motive was alleged to be. And this raises the issue of the power not to discriminate. We talk often about the power to discriminate, but we don't really talk about the power not to discriminate. And that's actually what's arising in the Queensland situation. The police have the power not to discriminate against the women, but they're actually choosing to do the opposite. And when we look at this legislation, when it came up to the High Court, the women had been prosecuted and convicted, and therefore they were appealing. The High Court looked at this expression for any unlawful purpose, and it clearly means for any unlawful object, being the real object. So this idea that they were there for some ulterior motive, even though it wasn't clear what they were there for, other than to demonstrate about the price of bread. And so here it says, the High Court says, is the suggestion that they are there with the ulterior motive of breaking the law or gaining notoriety. So what they're saying, it's like this issue about women being incredible. We aren't taken as credible in terms of what we say in evidence in courts. If a woman is raped, for example, if a woman has been sexually abused, raped, exploited as a child, and then when she's older brings a claim to the police, too often she's not believed. So it goes to the credibility. What they're saying is that when these women were up on the seat demonstrating and saying, we're here to say that Billy Hughes should do something about the cost of bread, the implication is they're just there to show off. They're there to make an exhibition of themselves. They're there deliberately to break the law. They're there to gain notoriety for themselves. And the High Court said that you can't simply assert that. You have to look at what actually is happening here, and might is not right. That is, the implication that was put forward by the magistrate and then the county court when they were arrested and prosecuted was that they were there, as I said, for some ulterior motive. And so the High Court looked at that issue. Are they there for an ulterior motive? Now, just to come to the second case, Adela Pankhurst was fined she was fined because she went out and contended that people, or asked people to throw rocks through the windows of the shops in Footscray. And in both these cases, the High Court had to determine whether the convictions were right. The point here is that when these two cases went to the High Court and when the High Court had dealt with them, they actually saw through the sham. So you've got High Court judges, all of whom are men, who are saying these women have been wrongly convicted. Now, when this case is actually reported by feminist historians, it's been reported in the Dictionary of Biography, for example, it's reported that they escaped on a technicality. They didn't escape on a technicality at all. They escaped on a substantive ground, namely that they had been wrongly convicted because the legislation had been interpreted wrongly, and subtext, it had been interpreted in a misogynist way to say what these women are standing up on that chair to say is not legitimate, and they're actually not legitimate operators in the political space. The second point about this case in its reporting by feminists is that they, in this Dictionary of Biography and in one other report that I found, they say it was Adele Pankhurst, Jenny Baines and one other. And Alice Souter is being written out of history by feminist historians. And when I've written about this, I wrote about it in the Women's History Network blog, the granddaughter of Alice Souter got in touch with me and she said, Alice Souter is my grandmother, my mother's mother. And they knew nothing about the history of Alice Souter at all. Their grandmother, Alice Souter, had also concealed from them this activist part she had, not, I think, because she felt ashamed of it. I'm sure she didn't, but perhaps it was because she believed it would not be seen as interesting. Now, as I said, she was 18 when she stood up on this park bench and spoke out. She was 35 when she got married. We therefore have to think, what did she do between 18 and 35? We know that if she got married at 35, she must actually have been activist in some way. And I would contend that there must be a lot of history that associates with Alice Souter that has never actually been written up, and a lot of activism. And I think that it's really important to bring attention to this case because it is women historians who have written her out of history. And if we look at the reason that we know that she was there, it's because of patriarchal recording. It's in the Commonwealth law reports. It's actually in the press reports at the time. And therefore, I think we need to be really careful when we're looking at the way that we analyse what goes on in terms of our culture and our society and the recording of what women do. Because, as I've said, it's the official recording, it's the patriarchal recording that actually acknowledges that Alice Souter lived. If there wasn't the patriarchal recording in the Commonwealth law reports, in the newspapers of the time, we wouldn't know anything about her. And if we read the feminist accounts of this, we wouldn't know anything about her either. So I draw attention to that. Now, with the second case, this also brings up something I find quite interesting as a lawyer, because in the second case where Adele Pankhurst was advocating throwing rocks through the window of the shops in West Footscray, the High Court actually upheld the conviction. So what they did is what courts, I'm afraid, quite often do. Because they had to hold that Alice Souter and Jenny Baines were not guilty, because the legislation had been interpreted wrongly in the court below, they had to find Adele Pankhurst not guilty then too. With the other case, she was alone, and they said that the guilty verdict was correct. And Adele Pankhurst, her mother, Emmeline Pankhurst, who we know of as a feminist hero, had actually been writing to Billy Hughes and saying it would be a good idea if Adele Pankhurst was effectively imprisoned. She wasn't in favour or in support of her daughter Adele at all. And the reason that Adele was in Australia was because she actually was persona non grata with her mother. That is, Adele Pankhurst was recognised in England and in the United Kingdom when she spoke at rallies and so on, as all of them did, Emmeline, Christabel, Sylvia, and Adele, or Adela. She was recognised as a great orator, and she therefore was a challenge to Christabel, the older daughter. And Emmeline Pankhurst wanted Christabel to be the one who did, who took actions that were valued, that were valorised and were seen as really important. So she got rid of Adele and sent her out here to Australia. And when Adele was in Australia demonstrating as she did, the mother was not supportive of her. And I just want to speak shortly about Adele Pankhurst, because I think too that she may well have been misrepresented. You see, she was active in this way during the First World War. She married a trade unionist, and then she became a member of the Guild of Empire. And the Guild of Empire is seen as a very right-wing organisation. Therefore, Adele Pankhurst is written up as this radical who then went all the way to becoming a conservative. I think more needs to be done in terms of looking at her rationale for what she did and what she really was as a political activist, whether she really was conventional in her older age or whether there's been a misrepresentation. Because you see, if we look at women's organisations, quite often we are very unfair to them. I know that when I became involved in the women's movement in the 1970s, I was a member of the Women's Electoral Lobby. And the Women's Electoral Lobby did some really good work. But there was also a sort of a view that the Australian Federation of Business and Professional Women and the National Council of Women and the League of Women Voters were sort of passé, and we didn't bother about them. They were sort of back in the dark ages. Now, in fact, they weren't at all. And I know that in the struggle for equal pay, the Australian Federation of Business and Professional Women were actually key to some of the achievements in that regard. The Women's Electoral Lobby was too, the National Council of Women was as well, and the League of Women's Voters was in there at one time too. The other issue I find interesting that needs to be reconsidered, in my opinion, is the issue of what happened in the 1950s. You see, the traditional view of women's activism and the women's movement is that it runs in waves, and that the vote was won and then somehow we all went home and did nothing. And particularly in the 1950s, after the Second World War, women all went home, did nothing, simply, I don't know, vegetated or were worried about putting food on the table for the husband. Well, it's not true, because I know from my work in this book, Wage Rage for Equal Pay, that the 1950s, in the 1950s, there was actually more activism and outspokenness and recording in the press of what women were doing in the argument for equal pay than there actually was in the 1960s, although we tend to think of the 1960s as a period of radicalism and the 1950s as a period when nothing happened. I also contend about this notion of waves, which I don't agree with at all. There are no waves in the women's movement, because if we say that there are waves, if we agree with this proposition, then what we're doing is, again, writing out of history all those women who existed and who were active and who were activists during the periods that we are saying are the slumps in the wave. And when do we say that the wave began and ended? The ridiculousness of this is that we have the first wave, so in fact we write out centuries of women's activism. We know that Christine de Pizan was writing in 1400 and something. We know that Mary Wollstonecraft was writing in the 18th century. We know that Mary Shelley was writing in the 19th century, and I'm just plucking those names out of the blue. It didn't all start in the 20th century, which the implication is, because that was when we won the vote. The activism for the vote and the activism of women, you can go back and you find it recorded again in the legal reports. Women were stopped from going to university because judges made decisions that women were not persons. And in 1860, there's a really famous case of Sophia Jex-Blake and 6 others. And what happened there was that Sophia Jex-Blake decided she wanted to be a medical practitioner. So she enrolled at Edinburgh University, and she was allowed to enrol. They let her in. Well, she got through the first year. A number of the male students didn't like it, and they brought a sheep or a goat, I've forgotten which, into the lecture theatre with a notice around its neck saying that this animal would do better than Sophia Jex-Blake. Well, the reality of it was that they were all upset because she was doing extremely well. And because she was enrolled, because she was studying medicine, because she was doing well, it attracted other women who decided they would enrol too. So 6 other women came forward to enrol. And it was at that stage that the University of Edinburgh decided that it was being invaded by women and that they had to do something to stop this. So they brought in the university visitor to look at it, and he said, well, I can't see that there's any problem, because the statute under which the university was brought into being said that any person with particular qualifications could enrol in the university. And he said, well, you've got these women wishing to enrol as persons in the university. But the university was not satisfied with that, and it went to the House of Lords. And in the House of Lords, the majority, there were 2 dissenting, said that the women were not entitled to go to university because women are not persons, and therefore they aren't covered by this provision that says persons with the particular qualifications could go to university. And who was the junior counsel on that case? It was Richard Pankhurst, that is Emmeline Pankhurst's husband. And when you read the judgments, what the judges are saying in that case, one of the arguments they had was that women should not go to university because no women had applied. Well, that means that, first of all, Sophia Jex-Blake was written out because she had applied, and these 6 women had applied too. But they were saying, well, no women had applied before. So if you go on the basis that because no women have applied, no women can go, it's a self-fulfilling prophecy. No women will be allowed to go because the first one that comes forward to enrol will be told, no, nobody's enrolled before you have. You can't do it. However, they were wrong. And Richard Pankhurst and his team brought out the fact that there was a professor at the University of Bologna in Italy right at that moment in any event. So clearly women elsewhere were going to university and enrolling and being accepted into that study. The other argument that was used was that if you're actually studying, it sends the blood to your brain, because in order for your brain to undertake study and to be operative in an activist way that's needed at university, then you need the blood up there. But women actually need the blood down there in the uterus in order to fulfill our God-given duty of bearing children. Well, we all see that that's a nonsense in and of itself, but it's also a contradiction of the reality of male procreation, because if a man's blood is up here in his brain, then it's not down there in his penis where it's necessary in order to engage in sexual intercourse to procreate. So their arguments simply don't have any validity, but these arguments continued to be made up until 1929. There are cases in Australia where women were prevented in Western Australia from going into legal practice. There was a case in South Australia where the woman was at last in legal practice and was prevented from going into another area of the practice of law because that particular act talked about persons. And in 1929, a case came up from Canada where the legislation that was relevant said that persons were entitled to be appointed to the Senate. That's their upper house. They've got the House of Commons as the lower house and the Senate as the upper. And these women said, we want to be appointed. And the Supreme Court said, no, you're not persons. And when the matter came to the Privy Council in England, London, and United Kingdom, as a part of the House of Lords, the man who was the president of the Privy Council clearly wanted to make his name. And unlike Alice Souter, Jenny Baines, and Adele Pankhurst, this was not used against him as somehow wanting to be important in that regard. But anyway, they held that women were persons. And so it was not until 1929 that we actually gained a legitimacy in the law as human beings, as persons. And if we have this history, it's a history that infuses itself into our brains, and therefore it's a part of the reason why the women police, for example, in the Queensland situation are not helpful, because they've got infused into their brains the patriarchal principles that that really somehow are embodied in all our brains, and that we have to fight so hard to eliminate. I just want to conclude this by speaking a little about the struggle for equal pay, because if we look at the struggle for equal pay, then we see very clearly that this idea of the waves of feminism is wrong. At the end of the 19th century, there was a huge struggle for equal pay, just as there was a huge struggle against the exploitation of women through prostitution, against rape in marriage, and against women having to pay taxes when we weren't recognised as citizens. So there was a huge amount of activism at that time that was building on activism that had occurred before. It just doesn't come out of the blue. It comes out of this long history that we have of activism and of achievement and of being pushed out, but also managing to get back in or stay back in. And this is another area where I think there's misrepresentation of what the reality is. We had a system in Australia of centralised wage fixing, and it was an Australian invention. And what happened under that was that the unions would come into this tribunal and the employers would come into the tribunal, and they would argue in front of the tribunal as to what the wages should be, what the conditions of work should be, and so on. And that meant that the strong unions came in, like the CFMEU. I know that they're in disrepute at the moment, but they have been a very strong and powerful and valuable union in terms of fighting for real rights that are valuable for workers. So, and the mining industry union, they come in and they'd argue for the conditions and for the wages. And eventually an outcome would come out as a basic wage case or a national wage case, for example. Now, that meant that the less strong unions, which are the women's unions, like the shop assistants union and so on, they benefited from what the strong unions did under this centralised wage fixing system. And then that was how we got equal pay recognised for the first time. And the equal pay was recognised for the first time, not in 1969, which is written up as if that's when it was recognised. It was recognised much earlier than that in a case that was in around 1907, 1910. It was one where women were working in the fruit industry, and some were doing picking and most were doing packing. If you were in picking, then you earn more money than if you were in packing, although ironically, in the case, it's recognised that packing is a more difficult job to do than picking. But what was decided there was that if women were doing the picking and that was a higher wage, then they had to get the higher wage, the same wage that the men did. That was an equal pay decision. The packing was still qualified as a lesser wage. And if the men were doing the packing, they would get the packing wage, not the higher wage that men got as pickers. So that's the first case that decided just on equal pay for equal work. And that's actually been ignored to a very large extent. And as I said, women in this field of equal pay worked all the way through, right through from the 1901 when the centralised wage fixing was introduced. They've been working before that, but I'm talking about the federal law here. And in 1969, again, there's a repeat of this idea, the equal pay for equal work. And then we have 1972 when the Whitlam government came in, and Mary Gaudron represented the government in that case, and it was decided that we should go beyond equal pay for equal work to equal pay for work of equal value. And then in 1974, there was a case that said that the minimum wage that had been stopped from being extended to women and extended only to men should be extended to women too. Now, what happened then was that the minimum wage was abolished, which is often what happens when we have our achievements. But I want to come to the point about this because in the 1980s, very sadly, the Labor government, the Hawke Labor government, and the ACTU, the Australian Council of Trade Unions, decided that centralised wage fixing was not the best system. And we went over to enterprise bargaining, which actually has put a real stopper on the whole struggle for equal pay. Because, as I said, when you have centralised wage fixing, it means that the strong unions go in and argue, and the argument that they put is an argument for the whole of the working sector. It's not just related to what they want to win for themselves. It operates on this collective idea that what comes out of the Commission is a standard that should be applied across the board, not meaning that everybody gets the same pay rate, but meaning that everybody will have the value of the increases that the argument has been put to the tribunal. under enterprise bargaining, which is what we have now, the strong unions go to the employers and argue, their employers, the employers of their workers, they argue specifically for increases in pay, for increases in conditions for their own workers. And there is no flow-on effect. So that if you belong to a strong union, as men tend to do, then you're going to end up with higher pay rates and better conditions than if you belong to a weaker union, which most women do, you're going to end up with lesser. And if you look at what happens in Australia now with the Fair Work Commission, it makes a basic wage decision, but that basic wage decision generally applies to a majority of workers who are women. And therefore, that's an indicator that there is something seriously wrong with the system. If those who are mostly impacted by the Fair Work decision, which is about the lower levels of pay, are women. The final point I do want to make about this, about equal pay, is that what we need to be struggling for is for a return to centralised wage fixing. The current government is making moves in that regard to a certain extent by saying that enterprise bargaining can take place across sectors and so on. But in the 1990s, what we fought for was work skills value inquiries, because even if we get back centralised wage fixing, which in my opinion we must, under centralised wage fixing, women's wages were more equal to men's than they are at the present time. Scandinavia was and remains ahead, and Australia was second to Scandinavia in terms of women's wages. But if you just look at the current situation, you're ignoring the historical undervaluing of women's work. And the reason that the minimum wage didn't apply to women was because it was regarded that jobs women did had no skills at all. And because at that time, what was being looked at was skills. And if you're held not to have skills, you're not going to get a decent wage. With these work skills value inquiries, which were done in the 90s and the early part of this century, what you look at is traditional women's jobs like librarianship, like teaching, like preschool teaching, like childcare, like elder care, like the whole welfare industry, where women predominate. And what you do is look at the skills that are contained within that particular trade or profession. And then you look at that skill compared with a similar skill in a men's trade or profession and see what it's paid over there. I actually raised this issue in one of the cases in the Arbitration Commission, just to give you a final example of the problem that we confront. And I was arguing that you can't set the national wage without looking at equal pay and this historical undervaluing of women's work. And the head of the commission was Justice Madden, said, well, you know, what do you mean women are paid properly, etc. And I said, well, no, you need to look at a secretarial work. If you look at a secretary, what a secretary is doing is keyboard skills. Therefore, you have to compare what she's being paid for those keyboard skills in comparison with what a man is being paid for keyboard skills in computer industry, right? And then I said, you also have to look at the fact that the secretaries have executive skills and compare them with executive skills that men are exercising. As soon as I said executive skills, Justice Madden's eyes lit up negatively, as if what I was saying was absolutely unacceptable. He could not accept that secretaries have executive skills. And why? Because he had a secretary, and he therefore undervalued the work that she was doing, and he could not comprehend or accept that the work that she was doing had that value. And you will often find this situation where women are doing a job, and if they weren't doing that job, the men that they're doing the job for would not be able to function properly. And you often find the case too that the woman will be doing a job and then she's asked to train up a man to take over some job and he will be paid at a high level, and she will continue doing the job, but at a far lower level than he is. So I conclude this by saying, read Wage. I've actually got some really great stuff in there, I have to say myself, because of all the research I've done, and I've intercut it with chapters where I acknowledge a whole host of women who've been involved in this, which means I've left some women out because it's inevitable when you try to name names. But we need to always name the names, and name as many names as we can, not just the ones that are seen as important, not just the ones who end up in powerful positions, but the ones who are actually working away, like all of you, and who make a difference to where women are and how we're valued and what we stand for. And the very fact that what's happening at the present time is negative to women is an affirmation that the work that we've done and that the achievements that we've gained are working, and that we have made these real achievements. We often think we didn't succeed in something, and we always have to remember that there is something that we've succeeded in. When I was the Deputy Commissioner of the Law Reform Commission of Victoria, I went into a meeting once to achieve 10 things. I was reorganising the commission. I had to achieve 10 things. I came out of that meeting and I got on the phone to my sister and I said, I'm a failure. It's terrible. I haven't achieved. And she said, well, what actually happened? And I said, well, I went in with these 10 things and I came out with 8. I didn't get those extra 2. She said, look, put those extra 2 on another list when you go back into a meeting. Think of another 8, put those 2 together in your list of 10 and go back and argue them, and you will achieve them that way. And she was absolutely right. We should always remember that we do have achievements, even if we don't get 100% of what it is that we've been arguing for. And we have to value those achievements and recognise them, whilst at the same time recognising that in order to achieve 100%, we've simply got to put in 100% again. And it's again and again and again. And we're fighting the battles over and over and over. But it does make a difference. And everyone's life makes a difference. Everyone on this call is making a massive difference to the rights of women. And I'm proud to be here together with you. And I thank you for indulging me about my, indulging in my legal, how can I put it, analysis of those cases about the Pankers. I hadn't actually realised it was so legally orientated, but I did just want to make the point. Remember, never write anybody out of history and herstory, number one, and number 2, remember that it's sometimes the patriarchal record that is the record that we need to see as the record of what we've done. Thank you.
Thank you, Jocelynne. I have to tell you that I'm incredibly moved, and I think everyone who's listening is gobsmacked and in awe of your wonderful work and your amazing service to women's liberation for such a long time. And we just love that you're still here doing it with us. Thank you. Thank you so much. Congratulations on yet another book.
Thank you. Thank you.
You're a fiend. I remember when you were saying, oh, I had to cut it from 100,000 words to 60,000. I was like, yep. Right. Yeah, that's you all over. You're brilliant. So,
oh, sorry, I'm saying it was 450,000 I had to cut to 150. Sorry to interrupt like this, yeah.
Oh, okay, well, that just makes the point even further, doesn't it? Sorry about the cat in the background. She's having the Zooms. So I would like to thank our amazing panel tonight. AWA, Karen Smith, thank you so much. Leah Whiston and Sue Clark from Woman Up Queensland, and the Honourable Dr Jocelynne A. Scutt, who is always such a treat to have along. I feel so honoured to have had this great discussion with you all. So I will stop the recording now, and we will get on to asking all those burning questions.